Thanks, Jeremy. Welcome, everyone, to our final TeachingAmericanHistory.org Saturday webinar in this series on landmark Supreme Court cases. These Saturday webinars are sponsored by the Ashbrook Center at Ashland University. TAH.org is the leading online resource for documents-based study of American history, government, and civics for teachers, students, and citizens. I'm Chris Burkett. I teach here at Ashland University, also co-chair of the Master of Arts in American History and Government program. And if you joined us before, you know that one of the purposes of these webinars is to pull together some interesting thinkers and scholars on these Supreme Court cases. And we also encourage all of you to join in our conversation today by submitting questions in the chat feature, and we'll try to get to as many of those as possible. You'll also, in the next week, receive a link in an email that will allow you to request a certificate of participation, and that email will also include a link to the archived video and audio from today's program. Today we're discussing a 1985 decision, New Jersey v. TLO, and I'm really happy to have with us today two people who know a lot about this subject. We have Eric Sands of Berry College and Jeff Sickinga of Ashland University. Both of you teach courses in our master's program on the Supreme Court and constitutional law, and I believe you've taught together in the past, so I'm happy to bring you back together, if only via the interwebs here, but it's good to have you both back together again on this topic, and thanks for joining us this morning.
Thanks for having us.
So, this is right up your guys' alley, Fourth Amendment case. I thought maybe what we do, if you don't mind, is just take us through sort of the broader significance of this case. Perhaps start with, if you don't mind, how did this case get before the Supreme Court, and why did this case become such an important, lead to such an important decision in 1985? Would either of you please just sort of introduce us to this case?
Sure. I'm happy to start if you don't mind, Eric.
Go right ahead.
Yeah, go ahead.
Sure. Well, I think everybody knows roughly speaking, the facts of the case. The student in Piscataway Township in New Jersey is suspected by the principal of breaking school rules. She's brought down and to the office. They search her purse, and in the process of the search find stuff that indicates that she's been breaking school rules, and so she actually ends up in front of juvenile court for delinquency. So it becomes a pretty serious situation for her, both civilly and criminally. And one of the interesting things to me about this case is the original question that the court was faced with when the case was presented to it was not the question they ended up deciding on. And this is interesting how the Supreme Court can kind of morph itself when it takes a case. Because the original question was actually whether or not the exclusionary rule applied to searches done by school officials. And the Supreme Court, when they were presented with that case, that idea actually said, whoa, we need to back up a little bit, because we need to decide, first of all, whether or not the Fourth Amendment applies to school officials, and then what it means to have an unreasonable search. Let's not assume that it applies to school officials, and let's not assume it's an unreasonable search, and therefore the only question is whether the exclusionary rule applied. The evidence can't be used against this girl. But let's take a step back and decide these more foundational issues. So this case, at first argument, did not seem like it was going to be such an important landmark, but it turned out to be, because the court went on to hold, yes, the Fourth Amendment does apply to school officials. For the first time, a clear, unambiguous ruling on that. And this is, as Chris said, as late as 1985, they had not really decided that question. And the second thing, of course, they decide is that search means something quite different when it's done in a school by school officials than if it's done by a police officer out in the regular adult world. So to me, those are a couple of really important aspects of this case that didn't start out that way, but ended up that way.
So just, this is really interesting. So do they ever answer the original question then in the process, Jeff, regarding the exclusionary rule?
Regarding the exclusionary rule, well,
Yeah, you said
because
the
they
original.
no, they didn't actually reach the issue of the exclusionary rule because they held that this was a permissible search. So the exclusionary rule, of course, only applies if officials conduct an impermissible search, and then the question is, but you get to keep the evidence in or not.
I see. Okay, that's interesting. So they didn't really need to answer that question. So the court took it upon themselves to broaden the scope. Why do you think that is, Jeff or Eric, either one? Why did the court broaden the question?
Good
Or
question.
is that too hard to ask?
Well, we don't know why exactly, because of course we're not privy to those things behind the scenes at the court. It would be great to be a fly on the wall, but I think it's because they realized that people were making assumptions in the lower court and among the attorneys. They were making assumptions about whether the Fourth Amendment applied, whether that this was in fact a search that was impermissible, that were just not legitimate to make. Occasionally the court does do that. It'll take a big step back and say, whoa, 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 there's other issues that need to be settled first.
I see. Okay. So I guess my next, I'm still trying to wrap my head around this. So this changes the role of school officials with regard to searches, permissible searches and seizures. Is that correct?
Yeah, I mean, I can even respond to one of the questions that's been posed about what about parents, and aren't the school officials representative of parents? And what's interesting is in this case, the court held very clearly that schools are not in loco parentis. So schools do not have the authority over students that parents have over their children. And so therefore the Fourth Amendment applies. I mean, the Fourth Amendment does not apply if you go search your kid's room. So, but it does apply if school officials search students. So that was actually a very significant ruling, and that had been coming for a while. Cases like, I'm sure the teachers know, Tinker versus Des Moines, the First Amendment case. Do students have First Amendment rights in schools? And the court held in 1969, yes, they do. So here they kind of extend that logic and say, yeah, you don't have First Amendment rights against your parents as much as teenagers would like that. And you don't have Fourth Amendment rights against your parents, but you do have First Amendment and Fourth Amendment rights in your school, because your school is not in place of the parents.
I see. Okay. Oh, that's very interesting. So what I'm again, pardon my ignorance on this, I'm trying to take in the significance of this as you're laying it out. So I'm just throwing this out here. We're gonna have to discuss it yet, but maybe we can come back to this later. It seems from what I'm hearing so far that the effect of the decision, in light of what you're just saying about the parents and sort of stepping back and looking at the Fourth Amendment more broadly, the authority of school officials over children is expanded somewhat as a result of this decision. Or is that not?
I'll let Eric take it. That's a hard question, actually.
It's hard, yeah. I'm sorry. So that's why I hesitated to throw it out there so early. But Eric, do you have any thoughts on this, or want to add anything to? Anything?
Well, I would say in some places this meant that school officials had expanded authority over children. To that question you had asked about why does the court, sort of change the fundamental question in the case, I think another factor in that is that state courts were actually badly divided on this question. You had some state courts that had ruled the Fourth Amendment did not apply to school officials because they act in loco parentis. So you don't need warrants, you don't need it. You can just search the kids anytime you want to. Some had ruled that the Fourth Amendment applied, but that the exclusionary rule did not. So even if the search violated the Fourth Amendment, any evidence found could still be used against the student at trial. Some held that the Fourth Amendment applied, but that the school official needed only reasonable suspicion to search. They didn't need probable cause. That was the case in New Jersey. That was the position the New Jersey Supreme Court took. And then at least 2 courts held that the Fourth Amendment applied and probable cause was required in order to search. So we're looking at a situation, among the states where there's a lot of differing opinions on exactly what the scope of the Fourth Amendment is when it applies to searches by school officials. And I think one of the things that's going on in this case is the Supreme Court is looking to provide clarification to these state courts and helping them to kind of unpack exactly what's allowed and what is not. In terms of what else is interesting about the case, there's a lot of times we talk about why does the Supreme Court make decisions and what sort of motivates their thinking. And sometimes it's just ruling on the law, but there are other cases where public policy seems to play a major role. And I think this is one of those cases. New Jersey presents a tremendous amount of evidence during the oral arguments about the amount of violence in schools and the amount of drug use in schools. And essentially arguing that school officials need to have broad discretion in being able to search kids for suspected wrongdoing, and that you can't tie their hands too much, or else schools are just going to become jungles where nothing, students aren't going to learn anything, nothing's going to get done, it's going to be a free-for-all. And you notice Justice White even makes reference to these studies in his majority opinion. He talks about the fact that we've seen these studies, and one of the studies that was referenced held that upwards of 3,000 students per day were victimized by violent crime in schools. Now, I mean, I'm not sure where that study came from, and I'm not sure about its validity, but I think this had a big impact on the justices, and I think played a role in getting them to think about trying to find a balance between, applying the Fourth Amendment and ensuring that students had some Fourth Amendment protection, but not going so far that it was significantly going to cripple or handicap school officials in being able to maintain order and discipline in the schools.
Those are great points, Eric. Especially the first, your first answer on the question of why that the federal, again, part of the sort of the general efforts of the courts in the late 20th century to establish sort of uniform federal rules regarding these things. That's a great point. And on your second point, just to throw this out there, do you think that the court did a good job of achieving what you say it was trying to do and establishing that balance between preserving some Fourth Amendment rights for students, but not tying the hands of school officials too much? Or I guess maybe that's a question about sort of the outcome of the case and the lasting impact of the case. But I hadn't thought about it in terms of trying to strike that balance the way you laid it out, Eric.
Yeah, I mean, I would answer that I'm not sure the court gives us a whole lot of guidance when it comes to what reasonable suspicion actually is. Remember, the New Jersey Supreme Court essentially ruled the exact same way that the Supreme Court does. They essentially apply a reasonableness standard to these school searches. The difference is that the New Jersey Supreme Court said that the search was unreasonable. And the Supreme Court says, no, we find it to be entirely reasonable. And when you get into the rationale that the two courts use for why one of them thought the search was unreasonable and one of them thought it was reasonable, and there's a lot of splitting hairs going on. Yeah, there's a lot of very, very nuanced, distinction being made between, what could be reasonably inferred by a school official and, what experience would lead them to believe that perhaps drugs would be present from the presence of being rolling papers in a purse and, all this kind of stuff. So I'm not really sure that the court places school officials on really firm ground after this in knowing exactly what a reasonable suspicion looks like and how it should be applied. But again, it based on other rulings that the court has made, that they seem to be deferring a bit more to the judgment of the school administrators than questioning it.
Yeah, I mean that's a great point. I mean, to try to define in advance what's reasonable is almost an impossible task. I mean, you would think that to say it has to be reasonable means we'll kind of know it when we see it, right? I mean, it's almost impossible to define in advance what's reasonable. So I appreciate the difficulty of that task, which makes me wonder again why the court consistently seems to want to define, what's reasonable in various cases. But since you raised this point, Eric, Larry submitted a question expressing some frustration at not being able to find good distinctions in his sources between reasonable suspicion and probable cause. So would one of you care to help Larry understand the distinction between reasonable suspicion and probable cause? That may be harder than it sounds given what Eric just said about trying to define reasonable suspicion.
Yeah, for sure. I really appreciate what Eric said there. Probable cause requires evidence. And I think, if you want to say give me one bright line distinction between reasonable suspicion and probable cause, I think that's one that you could certainly use. Probable cause, there has to be some actual evidence of wrongdoing. Now, it doesn't have to be evidence that would convince a jury, right? That's reasonable. That's guilty beyond a reasonable doubt. That's not the same as probable cause. But the cause part, I think, is important. There has to be some kind of causality there, and that requires some kind of evidence. Reasonable suspicion, the court has sometimes called it individualized suspicion. Sometimes they call it articulable suspicion. It's not a hunch. It's not something just didn't seem right. It's more dialed in than that. You have to be able to give reasons when you're asked, and they have to be specific reasons, but you don't have to have evidence supporting those reasons. And that's roughly speaking how the court has worked, including in cases like Terry v. Ohio, the stop, question, and frisk case. It's a standard that the court has applied a lot, especially in the late 20th century.
I see. That's very clear. So in this case, in the New Jersey v. TLO case, was it the principal who did the search? I can't remember the specifics. Whoever did the search of TLO.
Yeah, it's the vice principal.
The vice principal, right.
Did the search. There was no evidence that they found marijuana in the purse, right? And some money and some paraphernalia.
But as Eric said, they found rolling paper.
Rolling paper. Okay,
right.
but he didn't have evidence in advance to justify searching the purse for probable cause, which makes this a case of reasonable suspicion. And I guess the ground for the reasonable suspicion in this case was that the student lied about not having smoked in the bathroom. Am I thinking of this correctly?
That's right. So there's really two things, right? There's the cigarettes, but then there's the marijuana.
Right.
There's probable cause to believe the kid is breaking the cigarette policy because she's seen smoking.
Okay,
right?
So it is probable cause. Okay.
Well, for that, but not for the marijuana.
I see.
Because they don't find the marijuana in the first search. So then they say, but they find the rolling papers, and it's just, rolling papers. What could that mean? That's not quite probable cause if you were going to bring that to a judge and get a search warrant.
Okay. Okay, I'm still trying to. This is great. So the other issue in this case whether or not the vice principal was searching for evidence of cigarette smoking, but found marijuana and drug paraphernalia.
Well, didn't find marijuana first, right? Found rolling paper.
Oh, they found rolling paper first, but they did find a small amount of marijuana, didn't they?
Afterwards, yeah. After they found the rolling paper. So how do you go from rolling paper to another search of the purse and a really thorough search of the purse? How do you go from you go from the cigarettes to the rolling paper? Because that's sort of a plain view thing. They found it while they were searching. But how do you go from that to searching for marijuana? Well, you say, look, I know how things are in schools. If you find rolling paper, it's pretty reasonable to suspect that somebody's got some marijuana too.
Yeah.
That's almost classic reasonable suspicion.
Okay.
Is there evidence of marijuana? Which there could be, like the smell or something like that, which would not be marijuana but would be evidence of it? No, that wouldn't be. But you can reasonably suspect it given what you know as a vice principal of a public high school.
I see. Okay. So by the way, Larry says thanks. He said that was perfectly good, clear distinction. Gosh, what, I guess, again, back to, in light of what you're both saying, and Eric, feel free to jump in at any time if you'd like. Reasonable suspicion then. What does that mean then? Again, this is a tough question.
Sure.
How close can we get to saying because it sounds like, because the court leaves this so vague in a certain way.
Well, look, I don't want to, I'm always willing to criticize the Supreme Court, but
Okay.
they are interpreting the Fourth Amendment, which says no unreasonable searches and seizures. The amendment begs for interpretation, right?
Yes, yeah, it does.
Okay. So, look, they do give us two criteria for judging the reasonableness of a search. They say it has to be reasonable at its inception, and it has to be permissible in its scope. Okay. So it's not utterly amorphous. They have, is it reasonable in inception? Did they have a reason to conduct the search?
Okay.
And that means some kind, at least it appears from this case, although later on we realize it doesn't mean this, but it looks like in this case, it means you got to have some suspicion of that individual.
Yeah.
You can't just say, well, a bunch of freshmen we suspect they're selling drugs, or they're smoking cigarettes, so we're going to just search a bunch of freshmen. This case doesn't look like it permits that. It looks like it's reasonable in inception, means you got to have some suspicion of that individual kid. And then the scope of the search, you can't say, well, we suspect she has cigarettes and maybe marijuana, so we're going to search her purse, and then we're going to search every other thing she has and all the lockers around her, just as an example.
I see.
Now, later on, they seem to actually permit, as Eric was saying, later cases of drug testing that they use TLO to justify those cases. Very closely divided courts seem to go far beyond this case.
Okay.
But at least in this case, it looks like there's some criteria by which you can say, was that a reasonable suspicion or not?
Yeah, okay, but see, again, pardon me for getting hung up. That was perfectly clear, Jeff, and I am learning a lot from this, but I'm still hung up on, I mean, what, again, maybe it's an impossible question. What limits what is and isn't a reasonable search? I mean, if, stick with the example of schools here, since it's a school case. You've had a student who has been a drug violator in the past, or has been caught with marijuana in the past. Isn't it reasonable to say 6 months from now that we do another search, given the fact that that student has a history of being associated with drugs or having drugs? I mean, doesn't this open it up what's reasonable in terms of being a reasonable suspicion? Doesn't it open it up really to the discretion of people? And then who ultimately then is to decide whether that search was reasonable or not? It's got to be the courts in the end, right? Which leads to another question. Wouldn't this decision potentially lead to more and more cases of reasonable suspicion being brought before the courts? Okay, I'm asking way too many questions because I'm still trying to, sorry.
Well, I'll let Eric jump in. The only thing I would say is yes, it does, and it has. And so what the courts end up doing is deciding, the Supreme Court and the lower, especially it's really the lower courts who do most of the work on all this.
Okay, right.
They end up deciding on a case-by-case basis, was that reasonable suspicion?
Wow,
Was there
yeah.
reasonable suspicion? And then they have to weigh the privacy interests of the students, as the court says, right? You have to balance those against the government interest that's at stake, and you have to weigh them. And then courts do that weighing, and then the question is, was that a reasonable weighing? Was that a constitutional weighing? And you don't know that until the Supreme Court makes another decision.
Yeah.
So they end up taking on, as soon as you incorporate the Fourth Amendment against school officials, and so much searching goes on in schools, as all the folks here listening know, and has to go on.
Right.
As soon as you do that, you're going to have a multitude of cases in litigation.
That's right.
And that's what happens.
Yeah. Okay.
So they try and later on they try and set some parameters. So, what is it, about a few years later in the Vernonia case, they hold that the blanket drug testing policy for all school athletes is constitutional. And then they go on to say, because you were talking about what about if they're repeat offenders, then they just say, look, drugs are a problem across schools, particularly for athletic teams, we can't have it. So they uphold uniform, completely without individualized suspicion, drug testing of athletes. And then they extended even later to drug testing of all students participating in extracurriculars. They uphold a school district policy on that in 2002.
Wow.
So, we say, where does it stop? Well, it went that far at least. And then they walked it back a little bit in 2009 in a case where school officials strip searched a 13-year-old girl for ibuprofen. And there the court held that went too far. So
Okay.
but those are probably three biggest cases, that Supreme Court cases at least, that have come out of this,
And
that have
did
tried to define more clearly what is reasonable and not.
And in the case with the girl with this being searched for ibuprofen, was the argument that was an unreasonable search, that they had, it was based on not reasonable suspicion of something?
Well, yeah, what they argued there was they took the two-part test. Is it reasonable in its inception? And then is it permissible in its scope? And they said it was reasonable in its inception. They had reason to believe this girl was violating school policy about medication, which did not allow ibuprofen in the schools,
Okay.
but unprescribed from the school nurse. But they said, but it was not permissible in its scope. They went way too far in searching her, given the kind of stuff they were searching for. If they were searching for meth, then maybe you could strip search. But if they're searching for 400 milligram ibuprofen,
Yeah.
you can't go that far.
Wow, that's amazing. That's amazing.
Yeah, and Chris, I'd add to that. I mean, again, the court, I think, is looking to strike a balance here. We don't want the Fourth Amendment to be so encompassing that it's impossible for school officials to maintain order and discipline in their schools. But at the same time, I mean, the court doesn't want to allow, and they mentioned this in the opinion, New Jersey, in the re-argument, takes the position that essentially school officials are in loco parentis over students. And so the Fourth Amendment doesn't really apply. And it's a little weird because in the first argument, they actually said that they agreed with the New Jersey Supreme Court on the reasonableness standard. And then on the re-argument, they said, well, no, we're now going to argue about in loco parentis. But during the oral arguments, the justices peppered New Jersey with questions about, well, what kind of searches would you be okay with? Would you be okay with strip searches? New Jersey said yes. What about strip searches by people of the opposite gender? Yeah, that's not a problem. And then they even went so far as to say, well, what about two-way mirrors in the bathrooms? And New Jersey says, yeah, that's not a problem.
Wow.
And I mean, I think, that's kind of what we're dealing with here is we're not really comfortable opening up the door all the way to allowing school officials to just search willy-nilly in any way that they deem appropriate. There's got to be some check on this. There's got to be some, restriction on the ability to investigate either school wrongdoing or state or federal law violation. But yes, this is going to create a lot of litigation, but there already was a lot of litigation on this issue. This is giving some clarification by the Supreme Court on exactly what the issues are, how they should be applied, and trying to help courts in resolving what exactly should be going on in these types of cases.
Yeah, look, Eric's absolutely right about that. The only way the Supreme Court could have put an end to litigation of students against teachers and school officials would have been to agree with New Jersey that schools act in loco parentis and therefore they can do basically anything they want to the students, which is, by the way, a position that Justice Thomas has taken since 2007 in the Bong Hits for Jesus case on free speech with students. And he just said, no, we need to go back to he says the original understanding of schools were that they acted in place of private tutors and that the parents transferred authority to private tutors to school their children. And that authority was transferred then to schools. So schools do act, as he says, in loco parentis. So Thomas has actually adopted New Jersey's view, but nobody else has.
Wow, that's interesting. Yeah, because, okay, so that's very interesting, Jeff. So does this decision, insofar as we understand it, or insofar as it sets parameters and clear guidelines, Does this establish school officials as something like, well, let me put it this way. Does this actually give school officials something like police power? Because it seems to me that conducting searches is a police power, is it not? Is it traditionally considered a police power of the state? So does this, by sort of confirming that school officials can conduct these searches on reasonable suspicion, does that make school officials, not sure how I'm not formulating this question very clearly,
Yeah.
but it almost makes them agents of the state. I mean, they are, we know that in a certain sense, but this case really seems to affirm that.
This case makes that clear for the first time.
Okay.
In with respect to the Fourth Amendment, at least. Yeah,
Okay.
that's right. I mean, look, you could one of the other arguments that New Jersey makes that on the re-argument that Eric was referring to is that not only are the schools in loco parentis, so they can do whatever parents can do to their kids, but they also argue that students have no expectation of privacy. And this goes back to 1967 in the Katz case, where they said Fourth Amendment is violated when you violate someone's reasonable expectation of privacy. And there the court holds, right, if people remember, there's two prongs to that. Do you exhibit a desire for privacy, and is society prepared to accept that as reasonable? And there the court actually says, in the New Jersey argued in the re-argument, well, students have no reasonable expectation of privacy in any items that they bring with them to school, because there's no reason to bring personal items with you to school. So if you bring a personal item, you should not expect to have any privacy in that. If you bring a purse with you to school, don't expect to have privacy. And the court actually holds, and New Jersey compared it to prisons and said, look, prisoners don't have any expectation of privacy. And the court's response was, well, schools aren't prisons, even if they feel like it to students sometimes.
That's great. By the way, I'm chuckling a lot in this, partly because first of all, it's just amazing how complicated and convoluted this all gets in light of various decisions that the court makes, and then they have to come back with a ruling later to clarify the previous ruling, and then it's modified. It's just amusing, and I know it's serious, but it's just amazing. I'm also chuckling because I'm just always impressed by how much you two especially know, just how you can keep track of all this stuff. It's amazing. But
well, when you're talking about law, what is Oliver Wendell Holmes' dictum? I won't get it right, but I'll paraphrase it. Sort of an ounce of history is worth a pound of logic.
Yeah, right.
Something like that. Yeah.
Well, on that note,
so that's different. But to go back to your point about, your point about, so what are school officials is a nice question. And the court says, well, they're not parents, but they're also not prison guards. So they're somewhere in between there. They have a special custodial relationship, is the way the court puts it. So teachers are custodians, principals are custodians of the kids. They're not their parents, but they're not the police or they're not prison guards, and they're not quite police either. So they have police-like powers, they have parental-like powers, but they're none of those things. That really is at the heart of the complexity of the cases and the complexity of the case law, because what is a teacher? Are they a kid's parent? Well, sometimes they really do act like a kid's parent and help them out. Sometimes they have to act like a prison warden, and sometimes they kind of really what they're doing is somewhere in between that. And I think it's that the reality of the complexity of a school is responsible for a lot of the complexity of the decisions.
It's very well put.
I'd just add on to that really quick. Yes, school officials are responsible for enforcing federal and state law. There's no question about that. But they also enforce school policy, which may or may not have anything to do with legality and illegality. And this case, I think, illustrates that. TLO was caught smoking in the bathroom. That's not illegal. That's just against school policy. And so I think that custodian analogy works really well. Is they're enforcing a policy that's set down by the school in order to, again, maintain order, discipline, to keep the school, an environment conducive to learning. but isn't necessarily involved with finding somebody guilty of a crime. So they have responsibilities outside of those parameters as well.
And can I? One of the folks asked, "Is there a difference?
Yes.
Would there be a difference if the school was private?" It depends on the school. If a private school, as everybody knows, I think, can require things of students and parents that cannot be required of them in a public school. So you can, for example, religious schools. You can be asked to say, if your kid wants to come here, you have to sign that you agree with the following things. They could be theological statements, they could be school discipline issues, all of that kind of stuff. And I mean, it doesn't mean that the Constitution or the law doesn't apply to private schools at all, of course. But what parents can transfer a lot of their authority to a private school that a public school cannot require them to transfer. And I think that it could be a significant, but again, it depends on the private school. It's not automatic. It depends on what they require of parents and children coming into the school.
And Jeff, is that because of the sort of consensual nature of private schools versus the mandatory nature of public schools, or?
That's right. And because the court has held that private schools are associations and have the right of association according to their own rules of association.
That's very interesting. Okay. Very
Yeah.
good. Okay, well, good. That was I'm glad you asked that question or answered that question from Jim. I thought that was a great question. And then, Jeff, just a quick clarification. You mentioned the Katz case.
Yeah.
Can you spell that in case anybody wants to look that up?
Oh, sure. It's K-A-T-Z.
K-A-T-Z. Okay.
And it's an interesting case because it really sets the prior to 1967, as a lot of people I'm sure know, the Supreme Court had pretty much held that a search had to be a physical intrusion on someone's private property. Now, in this case, it might still have applied because it was her purse. But in 1967, the court holds that actually the Fourth Amendment protects privacy more than property. It doesn't say it doesn't protect property, but it says it protects privacy more than property. And so then it articulates, it's probably one of the most important and famous concurrences in all of Supreme Court history, where Justice Harlan says, well, I agree with the court, but they didn't quite make clear how you replace property with privacy. And then he articulates this two-pronged test in the Katz case. Very famous concurrence, and basically everybody after 1967 took that to be the Supreme Court's authoritative interpretation of the Fourth Amendment, including the court itself, and they started using this reasonable expectation of privacy test. But they made that up in 1967. Actually, Justice Harlan made it up in 67.
Wow. Thank you. That's very interesting. Just to mention that again, just in case somebody wants to follow up on this and look into that case further. I wanted to get to Laura. This is going back to the question of parents again. Well, I guess not quite, but something along those lines. Laura asked earlier, does the court not deal with the issue of a minor being unable to consent to a search? Does that come up in this case? The question of whether minors should have to consent to a search or not? Laura's question is, does the court not deal with the issue of a minor being unable to consent to a search? And I think she asked that as a follow-up possibly to the question of in parentis loco that you addressed earlier. Anybody want to tackle that?
Go ahead.
I think what the court is essentially saying here is if reasonable suspicion is found, it doesn't matter whether the student consents or not. The school official has the authority to conduct the search at that point, if again reasonable suspicion is discovered. The only thing in this case that comes up with the fact she's a minor actually had to do with a confession that she gave at the police station that the appeals court held was unconstitutional and sent back to the trial court for relitigation on a separate issue. As it turned out, TLO didn't want to really pursue that on appeal, and so it didn't go anywhere. But I think that's essentially one of the things the court is saying here is in the school environment, consent is not really an issue. It doesn't matter whether you're saying, well, I give you permission to search my bag, or I give you permission to, the question is, if you fall under reasonable suspicion, the school official has the authority to search your bag, search your purse, search your wallet, search whatever it is that they believe holds illegal or, against school rules, contraband.
That's amazing. And Eric, that leads, I think, maybe to a question that Candy submitted about drug sniffing dogs coming to classrooms. She points out that when the drug dogs come into the classroom during random searches, backpacks remain in the room, students step outside, they could have things on them, not in their backpacks. But what about dog searches? I mean, maybe this is getting too specific, but it's, again, based on the little I know about this, actually, Candy seems to be right when she says that when they bring dogs into schools, it's a random search. How is that consistent with the idea that there has to be some reasonable suspicion? Or is it just based on the assumption that high school students or middle school students it's reasonable to suspect that they're doing drugs?
No, it's not actually based on that.
Okay, all right.
Look, the court had held just prior to this in 1983. It's a case called U.S. v. Place, if anybody's interested. They had held actually that a dog sniff is not a search.
How is that not a search? Is it because it's done by a dog and not a human being?
It's done by a dog. Yeah, what they said, well, for two reasons. One is that it's minimally intrusive, so that it's not like they're actually going through your stuff. And the second thing they said is dogs are sniffing for contraband. So it's a drug sniffing dog, right? And the court held that society is not prepared. They went back to the CATS test and they said, second prong, you might want your marijuana to be secret, to be private, but society is not prepared to accept that you have a legitimate expectation of privacy in contraband. So as long as the dogs are sniffing for contraband, they can sniff in airports, they can sniff around cars, they can't sniff at checkpoints that aren't drug related, but they can sniff a lot of places for bombs or drugs because you don't have a legitimate expectation of privacy in those things. So the court says, so they're not actually a search. They're police appropriation of information.
Wow. Okay, that's amazing. So because those things are illegal, it's illegal for me to have drugs. I don't have a right to them. The dog can sniff and search and point or bark or do whatever and alert somebody that I have drugs on me. But because I don't have a right to have that, whatever it is that's illegal in the first place, it's perfectly acceptable for them to do random. So if I'm in an airport and I don't have anything illegal on me and a dog comes up and sniffs me, that's not really a search?
Yeah, well, it's interesting. The court held in 83 it's not a search, and a couple of the justices actually said, whoa, let's not say this. They didn't actually need to decide. It was a strange case, but they didn't need to decide the Fourth Amendment issue. There was a Fifth Amendment issue at issue there, and they decided to decide both of the issues, and a couple of the justices who concurred said, whoa, let's just decide this on Fifth Amendment grounds, not Fourth Amendment grounds, because this whole dog sniff thing is kind of new. We're not really sure about this. But the court ran with it anyways, and since then, that's been pretty binding precedent.
Now, in case you haven't noticed, we have started to venture outside of the school boundaries here because...
Oh, can I add one thing about the school situation, though?
Please, please go right ahead.
The one thing I will say is, unless you're in a particularly dangerous or like a place where security is of particular concern, like at an airport, the court has held that a dog sniff does require... You won't like this, but reasonable suspicion.
On the part of the dog. No, I'm just kidding.
Yeah, but look, okay. but not in a school.
Oh, come on. This is
Yeah. So they held that the court has held that out in the world, the police cannot just walk along with drug sniffing dogs and sniff civilians and citizens at random.
Okay.
They can't sniff you if you're pulled over at a checkpoint to check for licenses, for example. They cannot walk a dog around your car. That happened in Indianapolis in 2000. they can't walk a dog around your car unless they suspect, based on their first interview with you, that there might be drugs in your car.
I see.
But in the school situation, they don't need individualized suspicion to walk a dog and sniff the lockers and the kids in the room and everything else.
I see. So, but that's just schools, as you say. Outside of schools, it's a different.
Outside of schools, it's different.
Okay. So that leads to Larry's follow-up. Larry earlier was the one who asked about he wants a clear explanation between probable cause and reasonable suspicion. So is it that in a dog search, let's say, in schools, they can bring a dog in, a dog detects, or there's a term for it, I forget what the term is, but a dog detects something. Does that then give the searching officer probable cause or reasonable suspicion to conduct an individual search of a particular student? Or does it matter? Does the distinction matter at that point?
Well, no, at that point it does matter, and it's a positive dog sniff with a dog that's been well trained with an experienced handler. Those are all, it's not me walking my dog through there and I wouldn't know what I was doing. If those criteria are met, the court holds that a positive hit is probable cause.
I see. Okay, that's perfect.
Yeah, but what's interesting is not every justice has bought into that. So Justice Ginsburg, Justice Souter, even Justice Kagan and Sotomayor have kind of indicated, wait, but dogs can make mistakes.
Yeah.
They might hit on something, but even a well-trained dog might miss anywhere up to almost 50% sometimes. At least some studies show that. Again, Eric's right. You never know what to believe about studies, but they've said, so therefore, maybe that's not probable cause because it's not an ironclad identification of contraband.
Yeah.
But the majority of Supreme Court has never held that. They basically said, they call it the myth of the infallible dog.
Oh, that's very interesting. I've been sniffed a few times at airports by dogs, and never been carrying any illegal contraband, but still makes me nervous because of the dog. Because I know the dog's not perfect, or the dog is fallible. So as I was suggesting, we've been sort of straddling this line. I know there's the line in the case between what happens in a school and then sort of just out in the general public, among sort of the police. We've had a few questions along those lines. So it looks like a few people want to know, maybe I'll start with the broad question. How does the court's decision and attempt to define these things in the New Jersey v. TLO case, how does that affect searches outside of schools? Or does it? Does it affect that or does it not affect that? And you've started to talk a little bit about this, Jeff, already in your distinction with dog sniffing or drug sniffing dogs. But is there a broader impact just on sort of the general ability of the police to conduct searches in light of this decision? Eric, you have any thoughts on this?
Well, one of the things I'd say it did was it added to the number of exceptions that the court has carved out to the rule that you need warrants and probable cause in order to conduct a search. And there's a lot of these exceptions now. Depending on what source you consult and stuff, there's as many as 10 of these exceptions that we've carved out for it. One of the things I'd point out is that I did a very brief but did a survey of law review articles that were done on the TLO case. And, interestingly, there was a poll that was taken of the American Bar Association when this case was before the Supreme Court. And 54% of ABA lawyers had said that they'd agree with the New Jersey Supreme Court's rule on TLO. So agree with the reasonableness standard, but also agree that the search was unreasonable. And therefore shouldn't have been allowed. And by extension, that the evidence should have been suppressed. That seemed to track a lot of the law review articles that I looked at. The idea that the court was being too permissive of these types of searches and were infringing too much on student rights in schools. So interestingly, at least in the academy, the Supreme Court didn't get a whole lot of support for its decision in this case. The perception being that they erred too much on the side of supporting school officials and allowing searches to take place, and that they should have done more in terms of the Fourth Amendment to protect students, but also by creating yet another exception in the Fourth Amendment, we were slowly chipping away at Fourth Amendment protections overall. And that, eventually, when you have too many of these exceptions, the exceptions come to define the rule.
Yeah.
And we stopped worrying about warrant requirements, and we stopped worrying about probable cause. And we start going, well, everything just becomes kind of reasonableness at that point. That seems to be, as much as we want to. So I was kind of fascinated by seeing what, the legal community, how they responded to this case. And yeah, it wasn't particularly positive. It had a very negative cast to it overall.
That's very interesting. So since you brought up the sort of slippery slope thing, Eric, I wanted to ask both of you. This is I've always tried to understand. Jeff mentioned this earlier, where that sometimes police do random stops or what are they, checkpoints for. They used to do it when I was younger to make sure you had. They would pull you over and make you do a vehicle inspection or something like that, right? I don't know if I haven't seen those for a long time, at least not in Ohio. I know some states do this. But what about something like sobriety checkpoints? I've always wondered how that doesn't count as a kind of general warrant when police set up sobriety checkpoints. And don't take my question the wrong way. I'm not in favor of drunk driving, but how is that not a kind of just equivalent to a general warrant? We're going to pull everybody over and check them for drunk driving.
That's a good question. The court decided that in 1990, I think, in a case called Michigan v. Sitz, S-I-T-Z,
right.
And it was a 5-4 decision. So actually, 4 justices thought it was a general warrant. The 5 who sided with it said that because the checkpoints were connected to drunk driving and they were doing checkpoints on the road, that it was not a kind of warrant to search everybody for everything, but a particularized reason to have it that way. But and since then it kind of has, they checkpoints were set up for other things too. So they upheld checkpoints for Eric can correct me if I'm wrong, but they've upheld checkpoints for licenses and registration.
Yeah.
They've also upheld checkpoints for looking for illegal immigrants as well. But they drew the line at checkpoints for in 2000, a case called Indianapolis v. Edmond. They drew the line at checkpoints for just kind of, let's check people to see if there's any kind of criminal activity. That they said went too far.
That's clearly general.
They said that as a general warrant. But what's really interesting in that case is Justice Thomas wrote in a concurrence and said, well, if you accept the 1990 decision, then these cases are correct. But he said, but I'm not sure I accept that 1990 decision. And if I had been on the court, I might not have voted that same way. But since nobody brought this up in argument, I guess I have to go with the majority. So it's one of those really interesting cases where if a lawyer had just thought maybe we need to argue that the Sitz decision ought to be overturned, if Thomas had been on the court, it might have been 5-4 against the checkpoints. But the issue wasn't raised, and so now that's precedent, and they follow precedent.
That's very interesting. See, now maybe I'm just still living in 1774, 1775, but a search warrant. I always understood a search warrant to not be general. It has to be very specific as to the particular persons that are being searched and what's being searched for and what places are going to be searched. So I guess my perception of what a warrant had to be has been wrong all these years.
No, it's not wrong. It's just those are warrantless searches.
Oh, so those are exceptions carved out, as Eric was saying.
Yeah, but as Eric was saying, the court has recognized more and more exceptions to warrants and to probable cause. There are probably 10 exceptions to warrant now. And with a case like today's case, TLO, you not only have exceptions to warrant, but you have exceptions to probable cause. So I would say that there's definitely been more and more exceptions. And just to give you an example, Justice Scalia wrote in a case in 1968, the court decided the Terry case, so that stop, question, and frisk. And the police officers there just have to have individualized suspicion to stop someone, question them, and then frisk them for weapons, right? Well, Scalia said in a later case where the court didn't just police officers didn't just frisk someone, but actually felt inside their pockets, and the court held, well, that went too far. They said plain feel is okay, but not grabbing and squeezing. It's a funny case. But what Scalia wrote there, and wrote a concurrence and said, I actually think the original meaning of the Fourth Amendment and the founders' understanding of it does not allow police to stop and frisk, that the founders would never have permitted such a thing. And so what police can do is stop and question, and then if they don't like the person's answer, they can arrest them, and then subsequent to arrest, you can search people, obviously.
Wow. Well,
so he and Justice Thomas have argued for the original meaning of the Fourth Amendment is probably, in their view, more stringent, at least with adults outside of schools, more stringent than what the court has recognized in the last 30 or 40 years.
Yeah.
But that's outside of schools. Inside of schools, Justice Thomas says, school officials are parents. They can do whatever parents can do to their children. School officials can do that to the kids.
Yeah. Oh, that's amazing. I feel like this webinar so far has been one of those where I'm learning a lot, but the more I learn from you two, the more confused I'm getting in a way, because it's so complicated and it's so gray, and you've got to remember all these exceptions. But it's wonderful. I love it. So, since you raised, you keep bringing up Justice Thomas, Jeff, and I think that's really useful. And Candy submitted a question about. Let's see, Candy's question is, were there other friends of the court briefs from other district states that wanted clarification? Do we know what happened to Owens later in life? By the way, I was going to ask this question also, why the case is referred to as TLO.
Because she was a minor.
She was a minor, so they didn't actually publish her name in the decision, is that right?
Right.
But we know it's Owens, I believe, right? So were there other, if I understand Candy's question correctly, were there other districts or states wanting clarification, I guess, of the court as well? And a second question is, do we know what happened to Owens later in life? Either of you know? If not, it's okay. I don't know, actually. I don't know the answer to this.
I mean, there were friend of the court briefs. I know the ACLU filed briefs in support of TLO. The National Teachers Council or some organization like that had filed briefs on behalf of New Jersey. A couple others had weighed in as well. So I mean, none of them unpredictable or all that weird, given the nature of the case. But they had filed in and had weighed in on the issues and where they thought the different standards should come down in the case. But New Jersey and TLO were the ones to make the primary arguments before the court, and I don't see a lot of evidence that the court relied on the friend of the court briefs in this case, but
Okay.
They certainly did pay a lot of attention to oral arguments since they ordered them twice.
That's a good point. And do either of you just happen to know what happened to Owens? Just out of curiosity.
No, I don't actually.
No, I don't either.
I don't know. I do know that Choplick, the assistant principal who did the searching, was fired from his administrative responsibilities within a year after conducting the search. He went back to teaching and then was laid off after doing that. And then, of course, what caused him to rise to fame was the search of this girl's purse. He ended up working in a family-run hand.
Sorry, Eric, I didn't hear you.
He ended up working in a family-run handbag boutique.
You're kidding.
Oh,
And
the irony.
you
The
just
irony
can't
is
make
great.
this stuff up.
That's wonderful.
And so he was convinced that his firing was a result of the search and the lawsuit that came out of it. But nonetheless, he did not continue his career in teaching or in administration afterwards.
That's great. Thanks, Eric. That's great. So questions keep coming to me as we sort of start to wrap up here pretty soon. But I want to remind others joining us, please, if we've still got time for some more questions. If you want to submit a few more questions, please feel free to do so. But Jeff, again, you mentioned a couple of times Thomas and how Thomas would have, or how Thomas responded to similar questions in subsequent cases. Can we say something, either of you say something about just sort of the composition of the court at the time in 1985? I like to ask this question in every webinar. What's the leaning of the court in general? How would you describe the composition of the court, and maybe how does that, if it does, how does that have a bearing on the decision? Of course, we know the opinions, but how would you describe the court in 1985? And are there other justices?
Yeah, that's a great question.
Please.
I would describe it as centrist, if you want to put these kind of labels on things. So that's Justice White, who wrote the opinion. That's Justice Powell. That's Justice O'Connor. They're clearly middle of the road. Justice Berger, maybe a little on the conservative side of that, especially on Fourth Amendment issues. But then of course you have, we do have dissenters in this case, which we really haven't talked about. But you've got Justice Brennan and Justice Marshall, who were certainly not centrists, and by their own understanding, very strongly opposed to the method, to the original meaning approach to all of this, and very, very strongly in favor of warrants and probable cause. Justice Brennan dissented on a lot of Fourth Amendment cases. So you had, people on either side, but you had a group in the middle who was clearly looking to do the kind of balancing that Eric was talking about, and that's the way they wrote cases. Justice Powell and Justice O'Connor and Justice White constantly go back to, when they're talking about constitutional rights, weighing the person's constitutional interests, as they called them, versus government interests. They did that on all kinds of cases, and this would just be one example of that.
Yeah, that's great. So you mentioned Brennan. In the webinars this year, we haven't really had a case, I don't think, where we could talk about Brennan, but you mentioned Brennan as well, everybody should know Brennan's extremely important and I think in his own way influential justice at this time. I don't know if he actually wrote more. Oliver Wendell Holmes, of course, was famous for writing dissents. It seems to me Brennan writes a lot of dissents as well, as you mentioned, Jeff. Can we just say something about Brennan and his significance in the court in the 1980s? Do either of you mind saying something about Brennan?
Well, I'll say a few things, and Eric can jump in. He's a very important justice. There's absolutely no question about that. By the he was really important. He got on the court in the 50s, and he was there through the end of the 80s. And by the 80s, the court had, he was a leading voice writing opinions in the 50s and 60s for the Warren Court. By the time you get to the 70s and certainly the 80s, and the court starts to swing back a bit, he becomes a minority voice in the court, where he had been much more in the majority previously. So by this time, he's pretty used to dissenting, especially on Fourth Amendment kind of cases.
Right. Because I know him more for his dissents, interestingly enough.
He's probably the most famous and leading advocate of the living Constitution approach. He was open about it. He gave a speech actually in this year in 1985, responding to Ed Meese, Reagan's Attorney General, who argued we need to go back. The court needs to go back to the original understanding of the Constitution. And Brennan argued we can't do it, and even if we could, we shouldn't do it. He gave a speech to the Georgetown Law Symposium on this. And he said, and I refuse to go with this trend back toward original meaning. And he was really the leading advocate. And maybe Justice Ginsburg today is probably the closest in that same mold as Brennan, but even she probably is not quite as strong an advocate, at least as open an advocate of the living Constitution approach as Brennan. He came out of that tradition back in the 40s and 50s. and he embodied it thoroughly in his own thinking and jurisprudence all the way till when he retired from the court. And I think this is an example of that.
Yeah, I'm very familiar with his speech that he gave at Georgetown. I think it's called to the Text and Teaching Symposium.
Yeah.
Where he lays out very clearly his living constitutional arguments. So would you say, Eric, feel free to jump in on this as well if you'd like. Is it the 1980s when we start to see the term, Jeff, you mentioned it swings back a little bit. Is that where we see more and more originalist judges, so to speak? Again, go ahead and beat me up if you want over these labels, if you don't like these labels. But it seems to me that we get that the idea that a justice can be originalist becomes much more, I wouldn't say important, but at least more somehow more known, or it seems to be more important in the public mind that a judge is considered originalist after the 1980s. Let me ask you a question more clearly. Is it true that there are more originalist judges on the court after the mid 1980s, or were there already, they just didn't consider themselves originalists? Eric, do you know about the composition of the court? I know you do at that time.
Yeah, I mean, I think it's true that, after the 80s, we get more of these, originalist or textualist judges that are coming on the court. Some of that is, a concerted push that was made in the early 1980s by a group called the Federalist Society that was, I think, founded at the University of Chicago, or Chicago was maybe its second home, but Scalia was one of its first advisors. And the whole goal of the Federalist Society was to produce more of these textualist judges and to try to get them interested in public law, try to get them interested in taking position as federal judges, and then position them for runs, up to the Supreme Court, so they could be selected and influence public policy and influence the courts overall. So I think it's fair to say, textualism itself really starts to come into its own in the 80s and 90s, becomes a more discernible philosophy, a discernible judicial approach that is taken on. But there is a lot of nuance and texture to textualism. It's not, a lot of times it's articulated as just asking what the founders would do, and that's not actually what textualism is about. It's more asking about the meaning of things in their appropriate historical context, not just asking what James Madison would have done or asking what Alexander Hamilton would have done. And a lot of people kind of get those conceptions confused.
Yeah, I know. For example, that's a great point, Eric. Which is why I hesitated to throw the term originalist out there. Scalia, I believe, for example, preferred to be called known as a textualist.
Yeah.
And he was an originalist only insofar as the sort of understanding of the founders could be squared with the text of the Constitution. And then he had to write a 500-page book to explain, what textualism means, which was
right.
He also said textualism was the worst form of constitutional interpretation except for all the others.
Right.
So yeah. That was his take on it.
And what's particularly interesting to me, talking about the Fourth Amendment, since the rise of textualism and originalist judges, is just because a person is an originalist does not mean you can predict where they're going to decide, what they'll decide on Fourth Amendment cases. It's very interesting that way. That's not true on lots of other issues. If you know that a person is an originalist, you have a textualist, you have a pretty good sense of how they might decide on Commerce Clause cases, just as an example. Fourth Amendment's much trickier. Yeah. Scalia, as one of the most famous originalist textualist types, was a pretty strong, I'll call him my own view here, but a pretty strong defender of the Fourth Amendment, and pretty strong in defense of a strict requirements for warrants and probable cause. So, and his argument was, well, that's because that was what the Fourth Amendment originally was understood to mean, and that's what the text says. So because a person is an originalist, does not mean you can tell that they're always going to vote a certain way on cases involving the Fourth Amendment. It's pretty interesting. And even originalists now, like Justice Thomas, and then if you say, oh, I don't know, well, Justice Scalia, what it means to be an originalist for Fourth Amendment rights in schools, they have different opinions on that because they have different understandings of what the original understanding of a school was and whether school officials were in loco parentis or not. And so originalists might employ the same method, but they might come up with very different results. And you see that a lot in these Fourth Amendment cases.
Yeah, that's great. Jeff, I'm glad you went in that direction, because usually we get a question. We didn't get one this time, I'm surprised, but usually we get a question asking about something like how judges or justices on the current Supreme Court might, where they might lean on the same case, on the New Jersey v. TLO case. So just as a sort of fun thing, I know it's hard to predict, as you were just saying, so maybe that's the answer. But is there anybody on the court today that you might feel confident in having a guess as to where they might come down on a decision like this?
I don't know. They, in 2009, in the Safford v. Redding case, that's the strip search of the 13-year-old girl. I would commend that to the folks out there who are listening if they want to, how have they taken TLO, this case, and applied it as we go on. That case was 8-1 in favor of the girl who got strip searched.
Wow. And what year was that, Jeff?
That's 2009.
Wow.
It's called Safford. It's the school district's Safford v. Redding.
Okay.
So they accept the TLO precedent as the right test, but when they applied it to that case, they just said no. But the school officials went way too far, given what they were searching for, and it was 8-1 with only Justice Thomas dissenting, because again, his view was, well, the schools are in loco parentis, so they can search however they want for whatever they want. But none of the other justices, including many of those who are on the court now, right, including those folks, they did not go that way. They went with the court's view from TLO and said this was an unreasonable search.
Wow.
So how they would decide the TLO case originally, hard to say, but they now accept it as binding precedent, and they've used it to occasionally strike down searches.
Well, that's great. That was going to lead to my last question. We just have a minute or two left, but where does the TLO case stand today? It's still standing law, right? I mean, it's still a precedent. Okay. All right.
It's standing law and it's binding, and for the lower courts. And as Eric said, they've tried to work this out over time, what reasonableness is, and it's been extended to things like drug testing for athletes, extracurricular students, and the truth is, we always end up looking so much at the Supreme Court to define the meaning of the Constitution, but the Constitution's meaning is, in a way, defined every day. That schools are in operation and school officials have to formulate policy and then act on that policy, and it gets lived out by teachers and school officials all the time, every day. They're the ones who are doing most of, even if they don't know it, and I think most of the times they do know it, they're the ones who are doing a lot of the constitutional interpretation here.
Yeah, that's a great point. Well, and maybe a great point to wrap up on. And Erica, did you have I didn't mean to cut you off. If you had anything else you wanted to.
No, I completely agree with that, and I think it's one of the inherent dangers of focusing too narrowly on the Supreme Court in the study of the judiciary. When 99% of law is being made in the federal courts or in the state Supreme Courts. We really ought not lose sight of what's going on at those different state court levels and what's happening there. We talked about drug testing, but another area that the states have really taken the lead have been on metal detectors. And the use of metal detectors in schools. And pretty universally, the states have held that the use of the metal detectors is constitutional and consistent with the TLO opinion. I think those are important things to keep in mind.
Yeah, those are great points, Eric and Jeff. I think that's a great way to wrap up not only this webinar, but our whole series with some reminders about the role of the federal courts, and especially emphasis on the Supreme Court. So thank you both very much for being here. It's been really, really enlightening. And I really do appreciate your time and thought and your expertise on this. It was outstanding.
Well, thanks very much. Glad to be here.
Thank you.
Great. And also, thanks for submitting questions. For those of you who joined us today, really appreciate those questions. Just a quick reminder that, again, you'll receive an email with a link for your certificate of participation. I want to mention that we'll be back in the fall with 2 new series of webinars. One will be, again, a series of Saturday webinars, and our theme for next fall Saturday webinars will be moments of crisis. So we'll pick some particular moments in history that rise to levels of important decision making and focus on each one of those in a series of 10 webinars on Saturdays starting late summer, early fall. And we're also adding a webinar series on Wednesday evenings in which Dr. John Moser will lead a discussion on a particular document chosen from among the list of 50 core documents, which was published by the Ashbrook Center. If you want to find out more about these webinar series, go to tah.org. You can find out information about the series and also register for those series in advance if you'd like to. So take advantage of those. Hope to see you then. And until then, best wishes and take care. Jeff and Eric, thanks again. That was really, really wonderful.